If you or your child's been injured at a theme park or some sort of adventure park or jump park, these cases are extremely difficult because you probably signed a waiver at the start of the case. So if that happens, stay tuned. Hi, I'm Michael Coker. I'm a personal injury lawyer in Lawrenceville, Georgia, and today we're going to be talking about something that's really important to me, and that is injuries that happen in these jump parks, adventure parks, or theme parks. As you probably know, often when you go into these adventure parks or locations, they make you sign a waiver. Sometimes it's electronic on the computer. You're signing either for yourself or your child. And so, what happens if the facility is negligent and all of a sudden you have a ton of medical bills to pay for, but you're worried that you signed that injury waiver? Can you get around that waiver? And the answer to that question is yes, but only in certain circumstances. You see, in Georgia, we have a law that says that even if you sign a waiver, a facility or a company cannot waive what's called gross negligence. And what is gross negligence? It's not ordinary negligence, so it's not ordinary care or things that a normal, safe person would do. This would be as if the facility did something that was maybe had a habit of being unsafe, or they did something that just was no reasonable person would think is safe in that situation. That is called gross negligence. And in Georgia, you can still recover for gross negligence even if you sign a waiver. But it makes the case a lot more difficult. Ordinary negligence is a lot simpler, right? Just what would a reasonable person do in those situations? And so that's not the standard here. So the standard is elevated, which means that you need more negligence or more egregious negligence. Now, here's the issue. Is many of these places, the level of negligence does rise to gross negligence. Because at the end of the day, these are companies and they're trying to save as much money as they can on expenses to make as much profit as they can. And so when they're cutting those expenses to the point where they're trying to maximize their profits, they can't do that in such a way that it rises to gross negligence. So how are you going to know if the injury to you or to your child rises to the level of gross negligence? Well, the only way to do that is to speak to an attorney, because there's specific cases in Georgia of what amounts to gross negligence and what doesn't. And so you want to talk to an attorney and see if your specific circumstance for your specific injury or your child's injury fits one of these unique categories for gross negligence. That's how you can know whether or not you have a case. Now, we've successfully handled many of these cases against adventure parks, theme parks, trampoline parks. And so we know what rises to gross negligence and what doesn't. And so we can give you that, a free consultation, tell you if you have a case, tell you if it's worth pursuing. But even if you have a case that doesn't rise to gross negligence, sometimes in very limited circumstances, those waivers are also unenforceable. So Georgia contract law says that there are certain requirements that must be in every waiver to be enforceable. Things like it needs to stand out. It needs to be in a bright font. You need to, see it. You need to know that it's there, that you're signing away your rights. And so there's certain statutory requirements, meaning things that are in the law that the facility has to do to make sure that those waivers are enforceable. And you'd be surprised at how many of these parks don't hire a lawyer and don't take the time to make sure that their waivers that you sign complied with state law. And so many times, even those are unenforceable. And if the waiver or the release that you signed is unenforceable, then that brings the standard back to the ordinary negligence standard, or lowers that standards from gross negligence to ordinary negligence, and makes the case much easier to win. And so a good lawyer to handle these type of cases really has to be proficient in two different types of law. The first is contract law, because they got to know whether or not these waivers are enforceable, whether or not there's aspects of this specific contract that was stated correctly or the font was correct. But then they also have to be fluent in what is called tort law, which is understanding what types of cases fall under that gross negligence standard. And so, again, my firm has handled many of these cases. And we know, and we've spoken to many potential plaintiffs and given them a free consultation of whether or not they do or do not have a case, whether or not that waiver is enforceable, whether or not the standard rises to gross negligence. And so we'd be more than happy to give you a free consultation for your case and to give you the information that you need to make the decision as to whether to hire a lawyer or whether or not to pursue the claim. So if we can help you, give us a call. It's free. We're happy to talk to you, and there's no commitment. You don't have to sign with us, but at least you'll know that you have an experienced attorney who's given you the information that you need to understand whether or not you have a case. So if you like getting these updates, obviously like and subscribe to my podcast. But until next time, everyone stay safe out there, and we'll see you next time.